So yesterday was the worst day at the Madlanga Commission. They tore into, chewed down, gave an ultimate legal beating to the head of IDAC, Andrea Johnson. In this video, I'm going to show you this historical dress down. But if you stay with me right up until my biblical reaction, you're going to come out being so solid on due process, which is important for South Africa to prosper. And it will. And it is. You ready? Okay. Press like and let's go. Let's take you back to 6 July last year. Lieutenant General Nhlanhla Mkhwanazi, the police commissioner in KZN, comes out to the press briefing, says a lot of things about how cartels have infiltrated the justice system. So let me just remind you the allegation Mkhwanazi made a year ago.
On the 30th of May 2025, the Investigative Directorate Against Corruption, which is referred to as IDAC, requests the exhibits from the cell phone of Vusimuzi Cat Matlala from the political killings task team, and they download the content of the cell phone. IDAC is a unit that was established to deal with corruptions in the country. We don't know what is it that we're investigating for them to come and ask for these cell phone downloads. And on the 25th of June this year, the project coordinator of the political killings task team is arrested by IDAC.
So IDAC was initially set up after the Zondo Commission to deal with state capture because of how the comrades had looted SAA, Danal, and all the other state-owned enterprises. Now we see them being connected to the cartels by sabotaging the political killings task team by arresting Khumalo. Now this was a large allegation, and I kept an open mind right up until yesterday. In fact, just 3 months ago, when I was on the State of the Nation with Mike Sham, I was still kinda not sure like this.
And it's all happening by IDAC. Okay, now...
You talk about the police commissioner, not the Madlanga Commission commissioner.
Oh, no. The Madlanga Commission, yeah. The police commissioner, Masemola.
Masemola.
So Masemola is about to appear in jail. But
court
now...
First.
In court, sorry. Masemola is a good guy.
Yeah. Well,
okay. Until proven guilty. Okay, so Masemola is appearing in court. It's IDAC that's taking the 12 and him to court. So it makes sense because he's their accounting officer. But then we got to sit for 6 hours listening to the IDAC head. Okay, but I didn't come out with confidence that she's just doing her job. She had too many questions unanswered. Then you get to sit and say, this undermines trust in this whole system. You don't know what's going on. Why did you arrest the 12? Why is Masemola summoned? Is it because justice is happening for the 360 million tender? Or you trying to move him out of the way because other people's business is coming out and so it's management? We don't know, right? Because she sat in front of Parliament and she says a guy went to 2 police stations in 2 days and then jumped to a minister and jumped to me in 1 week. And I never asked what the heck's going on here, right? So this is the same IDAC that's been around for years, has done nothing on state capture for years, like Shamila Patoy's wonderful career, has done nothing on state capture and immediately jumps into this thing that has a lot of criminal and political interference. So it's, I don't know. I'm just seeing too many dots that I haven't put into a clean.
So that was my position 3 months ago, because the allegation was that Khumalo had hired Mukwili, a young lady, and apparently the project was a bit suspect. What was suspect, though, was that IDAC is this state capture, because it wasn't just some police station that went after Khumalo. It was IDAC, which is supposed to go after seriously complex state capture. However, I kept an open mind until yesterday when the IDAC boss appeared at the Madlanga Commission and for the first time got to really hear how she started the case, how she escalated the case, how she decided to arrest Khumalo, and all of it was so wrong. But don't hear it from me. Listen to this dress down.
3 key suspicions that Mr. Adams harbors. The first is at paragraph 2. It expresses his growing concern that the head of crime intelligence, General Khumalo, General Lushaba, General Madondo, and other senior crime intelligence officers are busy with systematic capture of crime intelligence division. That's his first suspicion.
Let's take it step by step. Do you agree that that's the first suspicion?
That is the first one.
All right, thank you.
Thank you, Chair. Paragraph 3, for purposes then of completeness, the deponent speaks to what became clearer to him, how his suspicion became clearer to him, but he adds nothing more. He references an envelope he says was slipped under the door of his office, but he doesn't share the contents of those. Yes. The second suspicion is reflected in paragraph 4. The first being a manipulation of procurement processes and processes to appoint and promote certain persons within crime intelligence. The second part is, calls for the need to investigate appointments at various Secret Service offices. Do you agree with me? That's all.
I have that.
At paragraph 5, he expresses a suspicion that some funds are being taken unlawfully from the secret funds account and given to Police Minister Becky Cele. It's a suspicion, but couched more in request terms, because he's requesting that you look into these matters, I guess, because these Secret Service offices in the country are likely points to money laundering out of crime intelligence. So in that, I can accept that there is a suspicion that there is money laundering, except that he would like IDAC to investigate. The last suspicion that he then highlights is at 7, at page 515. My suspicion is that General Khumalo, Lushaba, Madondo, and many of those who they've appointed are actively siphoning money from the secret fund accounts in the country. I understand that there are about 10 secret fund points in the country where monies can be drawn from, and all of these extraction points need to be investigated. That's another suspicion.
Okay, so these are the suspicions that Fadil Adams, the Member of Parliament, gave to IDAC, which then IDAC did a preliminary investigation, then an investigation, and then arrested Khumalo. And now we kind of check what made you move forward with these suspicions from Fadil Adams. That's the dress down.
So if we at least roughly summarized his suspicions, I can see how he has complied with Section 27A, which is to set out the suspicions of a crime that he complains of. I am missing part B of that, which requires him to set out the grounds on which the very suspicions that we have referenced are based. And my reading of this affidavit is that it's replete with suspicions, but absolutely no grounds to support any of the suspicions advanced, unless you can find any that perhaps I may have missed. Let's start with the suspicion at 2, that General Khumalo, Lushaba, Madondo, and other senior crime intelligence officers were busy with the systematic capture of the crime intelligence division. Let's just sit with that one suspicion. Where in this affidavit do I find grounds to support that suspicion, which then would tick A and B of Section 27?
So, first, in paragraph 2, line 1, Commissioners, he says, so the cases he refers to above must refer to what follows. And he says the cases were opened based on information I received from time to time, which places the SAP's crime intelligence, and then it follows. So he receives information from time to time. And he then says in paragraph 3 that suspicion became even clearer when an envelope pushed under his door at Parliament contained crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. So the grounds on which he bases it is information he receives. Information he receives from time to time, and further expounded by the fact that he has this envelope with further information that is pushed under his door.
That is did you base it on?
The genesis for the grounds on which his suspicion is based.
But you said he did not give IDAC that information which was slipped under his door.
That is correct.
So that's like saying, I have grounds, but I won't tell you what they are.
May I explain a further process that then happened? Sorry, Counsel, may I?
Absolutely, ma'am.
Because it might seem to jump the gun, but it will then perhaps provide more clarity. We received the Section 27. We received the dockets. IDAC takes the stance that an engagement has to happen with Mr. Adams because this 27 he did on his own and sent through to us. We have the dockets, but when they had the engagement, having read the dockets, having read the 27, it goes back to what I said. You then engage the person to see if there is other grounds that need to be covered. And further statements, Commissioners, were then taken in the engagements had with him in January of 2025.
I think where we are, Advocate Johnson, is that 27 says these things must be specified in the 27 affidavit. Because if you read 27, it says, by means of an affidavit or a firm declaration specifying ABC. So ABC are to be specified in the affidavit.
Correct.
They are not to be established at a later point. So the entry point is the affidavit which specifies A, B, and C.
And it is for those reasons, Commissioner Khumalo, that I referred to those two paragraphs. That is where I took that from, where were opened based on information I received from time to time, and the information placed under his door.
If perhaps you may assist us then. The suspicion is General Khumalo, Lushaba, and Madondo and others are busy with systematic capture of the Crime Intelligence Division. That's the suspicion. You are satisfied that that affidavit contains grounds to support that suspicion. Can you summarize those grounds for us?
Wow.
On my reading, Counsel,
yes, ma'am,
that suspicion is, he refers to the suspicion and he proceeds to explain, as he does in paragraph 4.
And what grounds are articulated in paragraph 4?
Says that he suspects that General Khumalo and some senior officers in crime intelligence, including
I apologize. I thought we agreed that paragraph 4 contains other suspicions. I'm still looking for the grounds for the suspicion that Khumalo et al. Are busy with systematic capture of crime intelligence. Where are the grounds for that? The manipulation of procurement processes and processes to appoint is another suspicion, the different one.
Yes, and I'm saying that it is based on, I don't read it to mean that every single suspicion is supposed to have a ground. If my reading is incorrect,
No,
I'm saying that is how I read it. I read it as I received information from time to time. From that information I received from time to time, there are all of these allegations, inclusive of the documents under my door.
Okay. You wanted to invoke paragraph 4 to establish the grounds. Remember, we still have to comply with section 27B.
Yes.
So we're going to have to at least find the grounds for the suspicion reflected in paragraph 2. You say those grounds lie in paragraph 4. And if you could just summarize them quickly for us. And simply because my reading of paragraph 4 is slightly different, but I'll take your perspective.
So the suspicion of the systemic capture lies in his suspicions in paragraph 4 in terms of, he refers to the procurement, manipulation, for lack of a better description, manipulation of appointment processes, bypassing of the vetting. Those are the ones that talk to the systemic capture of the crime intelligence division.
He's not, in paragraph 4, and what you're referring to now, he's not giving you facts that support his suspicion, because that's what 27B requires, the basis for his suspicion. What he does in 4, on its terms, he says, I suspect, that which you're referring to now, he says, I suspect that General Khumalo and other senior officers in crime intelligence, including Madondo and Lushaba, were manipulating procurement processes and processes to appoint and promote certain members to higher positions. So it's a suspicion. So you can't say, when we ask you that, okay, he's made the suspicion to you, so let's say he complies with A, what are the grounds that he has stated in his affidavit in support of that suspicion? You can't say where he states manipulating processes, procurement processes and processes to appoint, and then you say those are the grounds. That's faulty reasoning. It is a suspicion on his terms. It is. He tells you, that's what I suspect. The question to you is, where in the affidavit did you find that he has put down grounds for that suspicion?
On my reading, Commissioner Baloy, it is found for those ones on paragraph 3, where he said, my suspicion about General Khumalo and others became more clearer when I found an envelope pushed under my office door at Parliament, which contained some crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. I can take it no further than that is my reading of where he finds these suspicions.
Factual conclusion after factual conclusion, Advocate Johnson can never give you the facts that undergird those factual conclusions. All of the things you are addressing now are themselves factual conclusions. Do you understand what I'm saying? Do you understand what I'm saying?
If you could just take
those are factual conclusions. Let me
yes.
give you. Let me give you. You agree? Do you agree?
I understand.
Those are factual conclusions. Do you agree?
I agree.
So, if we go back to Ms. Silo's question, she wants to understand what that factual substratum is. What facts do you rely on to say those factual conclusions, and you now accept that they are factual conclusions? What facts underlie those conclusions to lead to the fact that B of 27 is satisfied? On what basis? It cannot be on the conclusions. Let me give you an example. If someone says, I suspect that Tom and Dick killed Harry, that's a conclusion. For you to be satisfied that there is a reasonable suspicion that Tom and Dick killed Harry, there must be some substantiation before you say Tom and Dick killed Harry. Do you get me?
I understand.
Otherwise, it's a factual conclusion to say that Tom and Harry killed Dick. And I suggest to you that this is exactly what you are doing. You are relying on factual conclusions to say that B of Section 27 has been satisfied. Do you agree?
I agree.
You accept that proposition?
I accept your proposition.
Yes, Mr.
Thank you, Chair. And then, following that very same approach to all the concerns, I'm going to put it broad. Where in this affidavit do you find any grounds that can potentially get anywhere close to Section 27B? And I put it that way because I'm talking to a lawyer of 30 years experience who appreciates when a statute prescribes what jurisdictional factors must exist before certain outcomes are achieved, you would understand that they have to be satisfied independently of one another. It's first A, the suspicion, B, the grounds. Where in this affidavit do you find the grounds that would satisfy the requirements of Section 27B?
I have referred to those grounds and say that, having heard what the chair has indicated, there's nothing more than just what he said here. It is a matter of, he says, this is what I have, information and documentation. I think the question, and sorry, Commissioners, I don't mean to be asking you all a question, but what I'm trying to pose for myself is, the question then is that sufficient for B?
Was there a sufficient factual substratum to satisfy B of Section 27? That's the question. And I think in response to my question, you've accepted that there was none.
In terms of the factual basis of it, yes.
The factual basis that undergirds or supports the factual conclusion.
Correct.
You've accepted that there was none.
Yes.
Do you then accept on that basis, because my and your engagement had started on the basis of the first suspicion,
yes,
which is state capture, would you accept that there is no factual basis advanced in this affidavit in respect of all the suspicions as you have identified them? Would that be correct?
That would be correct, except he says so of
his conclusions.
His conclusions of, I have information and I receive information and I also had information. It is on that basis, yes.
If that's where we land, would such an affidavit comply with the requirements of Section 27? And what would be the consequences of non-compliance?
So given the questions that were posed by the chair, it was, I had not looked at it.
And not only the questions and the responses.
Yes. So on the basis thereof, Commissioners, I've applied my mind differently. The Commission has pointed something out quite differently that ought to have been considered. I'm saying in the manner in which I applied my mind at the time, based on how I understood Section B, or what Section B to mean, at the time, yes, I agreed that it fulfilled that requirement because he had knowledge, he had grounds on which it was based. I've given the answer, Commissioner.
So
I can't change that answer.
Are you seriously telling us that since what you've been the director since 2022, is it?
Yes.
Are you telling us that since 2022, this is how you've understood your legal mandate, or
No.
IDAC's legal mandate?
No.
Did I understand you correctly to suggest that you understood that the suspicion required has to be viewed subjectively? Did I understand you to say that? I'm asking you this because you said you believe that he had the required suspicion. He, Mr. Adams.
Yes.
Did I understand you correctly?
Correct.
So that's subjective as opposed to objective. So did you understand the test to be a subjective test as opposed to an objective test?
For me, the grounds on which the suspicion is based is a subjective test.
I will.
No, I'm not going back on the argument.
Okay,
I'm saying in the way I've applied my mind, this is a reasonable suspicion.
What she understood as her job is that she can make Fadil Adams king of South Africa before 1215, when the Magna Carta came in that said kings can't just make decisions and kill people if they want, punish people if they want, take land from them if they want. She understood her job as this: if King Fadil Adams says arrest the head of crime intelligence, she can just say King Fadil Adams believes he should be arrested, and she put in motion to go arrest him. She took South Africa back 500 years. We know this. You can't arrest someone unless you have objective facts backing up suspicions. Why do we have hearings? You can't even be fired from work like this.
This is a reasonable suspicion.
Yes.
That must be borne by a reasonable man and a person, by a reasonable person who must have access to knowledge and or information that brings them to that point. If you would allow me to just take it just a moment further.
Yes.
Mr. Adams is a member of the Police Portfolio Committee. These allegations come to them from time to time. There's active engagement with the police. There are documents that are shared. There's information that is shared. I did not take his to be just the test of a subjective mind of just a reasonable man.
No. You can't obfuscate issues in the manner in which you are saying. You said you considered the test to be subjective. Now you are saying something that suggests that somehow you also considered it to be objective. You cannot have it both ways. Please, Advocate Johnson. Let me ask you the question again. Did you consider the test to be subjective?
Correct.
Now what are you saying? You've just said something that seems to suggest that you also considered it to be objective. Make me understand what you are saying.
Maybe I didn't express myself correctly. I'm saying that the reasonable man test, the person test, applies. But
once you see therein lies the problem. Once you say that the test is subjective, then you look to what was going on in a specific person's mind. That's subjective. It has nothing to do with a reasonable person. That's subjective. You cannot have it both ways. Law 101 says subjective, you look to the person's mind. Objective, you test that in accordance with how a reasonable person would view the situation. The two are totally different. You cannot want to compound them. You simply cannot. You cannot say it's subjective, but then also refer to a reasonable person test. You cannot. I mean, even a law student doing first year would know that at a later stage during their first year of legal studies. In fact, across the board within legal studies, you go to your law of delict, you go to even criminal law, your culpable homicide, you encounter the reasonable test across the board. So how you could mix the subjective test and the objective test completely escapes me. So back to my question, you have said you accept, or rather you say the test under section 27 is a subjective test. Do you stand by that? Because if you do, it raises very serious issues about your application of the section
Yes.
over all these years. Are you sticking to your assertion that the test is subjective, even though it uses reasonable? Once you have reasonable, that leads to the objective test. You should know that.
Yes.
Are you insisting that the test is subjective?
It is an objective test of the reasonable person.
It's an objective test.
Yes.
Yeah, you don't even need to go to reasonable person. Reasonable person is implied in the concept of an objective test. So you don't even need to go there. Now, if it is objective, did you operate, when you looked at this referral, did you operate on the basis that here I'm concerned with the objective test? Is that how you applied it? Because my sense when you responded to Ms. Sillo was that you thought it's subjective. And indeed, even here, until my 2 or so questions before now, you were saying it's subjective. It's subjective. So that must clearly mean that you looked at this referral affidavit on the basis that the test was subjective. Is that so? Is that so?
I looked at the section 27 on the test of the
Subjective, it must be.
At the time, yes.
It must be, because that's what you believed. Hence your answers on a few good times now during this engagement, your answers that the test is subjective. So you looked at this on the basis that it is subjective. You agree again?
Yes.
So that means in your case, the word reasonable, which appears in so many words in section 27, did not come into the equation whatsoever. Is that so?
It does. Because
no, it couldn't. Not if the test is subjective according to you. It wouldn't. Because once you talk reasonable, that takes you to the objective test. And you have said, in your mind, that did not apply. So you looked at this on the basis that it was the subjective test that applied, correct?
Correct.
So reasonable did not come into the equation to your mind, correct?
The reasonable that comes to mind is as per any person has reasonable grounds to suspect. It dealt with the offenses, which was part A.
It's there fine, and you are reading it fine. But what I'm saying is, if you believe that the test is subjective, then reasonable, on your understanding, does not come into the equation. Because once you bring into the equation the word reasonable, that's already taking you to the objective test. You have said, on your understanding, the test was subjective. Therefore, reasonable would not have come into your equation, not on your approach. You must accept that.
I hear you, Commissioner.
Do you accept it?
I accept that.
Thank you.
Based on the engagement you just had with the chair, would it be a fair understanding that all your approaches to all Section 27 referrals you've had is the attitude you had to this particular one? So IDAC initiated investigations based on numerous of such affidavits which don't advance any grounds to support suspicions expressed therein. Has that been the case throughout the years you've been at IDAC?
No, ma'am.
And why then how have the other affidavits been dealt with? Have you interrogated their compliance with Section 27 before initiating an investigation?
Yes, the other affidavits were quite different. You'd also see, I think you requested from us the affidavit of a different witness. When you read those as well, you can see the compliance with these sections.
Why didn't you bring to bear that particular need for compliance to this particular affidavit, which is dated less than 2 years ago, November 24? Why did you treat this affidavit as an exception to the rule that you say you had come to apply to all other Section 27 affidavits?
So I'm not going back.
Yes.
Okay. And I think that is where my fault line lay, is understanding what the reasonable person, and went back into subjective. That was my error. It is an error. It was an honest error. The test isn't subjective. The test is objective. Here I brought a subjective mind to bear on the information the person gave us.
And Advocate Johnson, that is apparent from paragraph 4, because Mr. Adams says none of these people were suitable to be appointed to the post. That's his personal view, without
Correct.
grounds to support that.
Correct.
He doesn't even say they did not meet the minimum criteria, they did not have the qualifications. He just says, you appointed somebody from BMW as a brigadier, and then he says, not suitable, full stop. Why are they not suitable? Do they not meet the qualifications? He does not even identify the offense that he suspects is being committed there. Because appointment of somebody from BMW on its own does not tell you anything. Because my immediate question would be, what is wrong with appointing somebody, an engineer from BMW? If the position required an engineer, what would be wrong with that?
Correct.
That would be my immediate question. And I would need that to be addressed in the affidavit itself. Because the entry point, according to Section 27, is that the affidavit must specify 1, 2, 3. Not that it must set out the suspicion and then the grounds IDAC will figure them out for itself.
Understood.
Just on an answer you gave in response to Ms. Sillo,
Yes,
you
sir.
said an error that you committed was not to apply was to apply the subjective test. The test is in fact objective. In that response, based on the answers you gave to me, and repeating the same thing a good few times throughout until your engagement with me, the distinct impression I got was that you've always understood the test to be subjective. Correct?
I understood the test to be the reasonable person test, which is an objective test.
So throughout, your understanding of Section 27 was in accordance with the responses you gave when I engaged you. As to what those were, the transcript will assist us. So before now, you had, I feel bad to have to use this word, but your understanding was this muddled view of what the test was, which muddled view came out as I engaged you. So that was your understanding until now, until during this engagement. Is that a fair suggestion to you?
It is fair.
Thank you.
Even allowing for it was an error, you applied the subjective test because of your misunderstanding of the test that applies. Even on that, in this affidavit, insofar as 27B requires him to set out grounds, this affidavit doesn't set out any grounds. To say I received an envelope that has procurement matters, that's not a ground. It doesn't tell you anything about the contents of the envelope. For all I care, those procurement documents may well not demonstrate anything wrong. So it's not clear to me when you say, well, I accepted because he's a member of parliament who serves in the portfolio committee, that when he says he has an envelope that is sufficient, you surely must know and understand that for you to say this falls within our mandate, you need to satisfy yourself with whatever it is he's relying on. So I don't accept that what you say is an error on your part of applying the wrong test, that it explains what happened here. It doesn't. Even on that error, I would expect you, as you understand the section, it says he must set out grounds, and he doesn't. He doesn't. When he goes on to say 4 other colonels who qualified or who are employed in crime intelligence, none of them were suitable to be appointed in this post, it doesn't tell you anything about this candidate that was appointed. It doesn't. So it is clear in 27B that he does need to tell you facts. Subjectively, he thinks those facts meet the test, but you have to know those facts before you say, yes, our mandate is triggered. You must agree with me. I must be correct in what I'm saying.
I'm not about to disagree.
Okay, thank you.
So she basically allowed the minister and Adams to just use her like a tool to go and arrest Khumalo, while there was a letter from the same minister to disestablish the political killings task team. And it was around the time when Mkhwanazi says the political killings task team was creating a problem for cartels. So, one of two things. She's still lying, she was protecting cartels. Or number 2, she has less common sense than the average South African. I struggle to believe it from a prosecutor who's been putting people in jail, running trials. She knows how to back up what you say with real evidence and grounds and facts. She knows. And if she doesn't know, who in the world would put her at the level that she's at? So anyway, after that dressing down, she suddenly had to go home.
Advocate Johnson has made a request to us as evidence leaders, which request I table to the commissioners for consideration. Advocate Johnson has requested that we sit until 4, but may she be excused at 3 this afternoon. She's, as the chair is aware, currently on medication following her illness last week. And I'm made to understand that the medication she's on is having some debilitating effect on her. So she has requested an early stand down today at 3 o'clock.
I confirm that, Chair. There was that communicated to me by Ms. Johnson. I communicated it to Ms. Sello, and that's where we are. Thank you.
Thank you, Ms. Sello. Thank you, Mr. Bodlani. We will adjourn at 3 p.m. then.
Thank you, Chair.
Thank you.
And the best summary of everything that IDAC has done with this Khumalo issue was by Commissioner Baloyi.
The difficulty is that you don't seem to abide the terms of this section 27. Even if she proposes the names to you, you are the final decision maker, you are the in charge, you are the one that's authorizing an investigation. It's difficult to conceive of a situation where she comes back to you and she gives you a list of names and you don't say, no, we can't do that because it doesn't arise from this affidavit. We haven't started an investigation, so I know you didn't get those names from an investigation. I know you didn't do that. We have at this point only this affidavit. And you don't say, we are obliged to work with what we've got. We can't do whatever we feel like. It's difficult to understand that you would be party. If this is her giving, she gave you these names, that you are happy to sign off a truly invasive investigation, because your powers to hear evidence means you can call these people, you can look into their affairs. That's what it means. And you do it outside the corners of the only document you have on which you could work with. You, the head, are not in a position, and you do not say to your prosecutor that we are not doing that. We are bound by law, we are bound by rules to investigate that which is properly given to us. It's a misuse of powers, whether it comes from her or from you. At this stage, this is a misuse of powers to take intrusive steps and action against people on this affidavit. You have no justification whatsoever on this affidavit to be looking into Likalakala, Ngobe, Moyani, Sibula, Madileng, Mokwele even, by name, Duvalo, whoever is automotive engineer. You have absolutely no legitimate and valid basis to look into them. Maybe there is something to look at later on, but we are still at this affidavit stage where you are authorizing that they be called in, that their affairs, their bank statements be looked into, and their lifestyles and everything and about them. And they must come to interviews under threat of, if you do not cooperate, it's a criminal offense. You're happy to do all of that, when in fact the document, the only document on which you rely to act as you do in this document, doesn't create a basis for it. It's to me, it's yet another instance where you, in particular, have misused your powers to go where you are not authorized to go. There's no legitimate basis to do this. Do you want to comment?
I have no comment, Chair.
This was painful to watch. My biblical reaction. Then I commanded your judges at that time, saying, hear the cases between your brethren, hearing's important, and judge righteously between a man and his brother. You shall not show partiality in judgment. You shall hear the small as well as the great. You shall not be afraid in any man's presence, for the judgment is God's. One of the things that has been quite interesting about the Mkhwanazi allegations is watching how citizens have kind of become pretty good at due process. What is due process? It's very simple. Specific allegations, not rumors, not kind of saying this, kind of saying that. Specific allegations like Nhlanhla Mkhwanazi brought. Now, once you get specific allegations, you have to give the other side an opportunity which is fair and impartial to give you the other side. So they must get notice, they must be heard, and it should be fair. And then at the end of that, you take a just decision. Now, this is important for you and I as citizens. Whenever you hear specific allegations, due process only starts because there are specific allegations. Now, what must happen? The other side must then give their side of the story in a fair environment, in an impartial environment, and hopefully the fair, impartial person will at the end judge and make a decision. Now, we also have to judge as citizens, and I want to help you with this. Whenever you hear specific allegations, due process must take those allegations to a conclusion, which is it true or false? Now, what happened with Mkhwanazi? He came out and he said, this and this has happened. And as citizens who understand due process, then keep our eye on those allegations to get to a place where after the other side is heard fairly and impartially, we get to say, was that true or false? Mkhwanazi came out, he said cartels have infiltrated justice system. Well, some people came out and they started saying, What if Mkhwanazi has political ambitions? Other people came out. You saw them in parliament saying, what if this is about factions in the police? That's a new allegations. There are factions in the police. Now go off to the right forum, make those allegations so that due process can happen there. Right now, we're waiting for this. Oh, but Mkhwanazi came out dressed in military garb when he made the allegations. Great. That's a new allegation that he wore the wrong clothes, and that's a problem. Go to the right forum, lay those allegations so that due process can happen there. Right now, we're trying to find out, was what Mkhwanazi said true? Now, the last thing that was left to find out if it was true or not is that he said IDAC, a whole institution like IDAC that was designed to fight state capture. He said they arrested the project manager of the political killings task team to get him out of the way because PKTT was creating problems with criminals. After due process, for myself, not for Justice Madlanga, for myself, that was the last part where I had to hear the other side. I heard the other side yesterday. And this is what I'm saying. What Mkhwanazi said is true. IDAC arrested Khumalo for other reasons than that they were just doing their work. So, as a citizen, this is what I encourage you to do. First of all, when you get non-allegations like innuendos that suggest whatever, you can ignore it. It's just politics. But when you hear specific allegations, your responsibility as a citizen is to wait to be clear about, is that true? And so that comes with a hearing, that comes with impartiality, that comes with judging righteously or fairly, and to get to a conclusion that says, was it true? And I am shocked that the one allegation Nhlanhla Mkhwanazi made, that was the hardest one for me to swallow. Yeah, it has merit, serious merit. Is it true? Probably. Cartels were using IDAC. Do we have proof? We don't, but they weren't going to tell us if it's absolutely true. But what we've seen so far is that going after Khumalo was an abuse of power based on nothing except that the police minister helped Fadil Adams to write Hot Air Section 27, and an advocate, Andrea Johnson, ran with the hot air to quickly arrest Khumalo. Someone says, oh, but maybe Khumalo's appointment is wrong. Good. Go lay that allegation at the right forum. Let it start there. Don't bring it into this one, because due process works like that. Allegation, fair, impartial hearing, judgment. I have made a judgment on this matter, and it's this. So far, there is not a single allegation of Nhlanhla Mkhwanazi that has been shown to be false. Now that's scary, but it's also exciting, because in the process, a lot of good has happened. Let me hear your thoughts below about due process. No man can serve two masters, for either he'll love the one or hate the other, or he'll despise the one and honor the other. You can't serve God and Karl Marx. So many people missed the opportunity to be on the right side of due process, including some of the parties who are known, whom we rely on for upholding due process in our national operation. Disappointing. But let me hear your thoughts below. Let's make history together. Cheers.